Welcome to this Royal College of Psychiatrists in Scotland webinar on the emergency mental health legislation that we have available to us in Scotland. It's very important to note from the outset that this legislation has not yet been activated, but it's prudent for us to think about it in case it needs to come into force. I'm joined by Arun Chopra and Roger Smyth today, two colleagues of mine who I'm delighted are experts on this topic. We're recording this webinar on Friday, the 24th of April, 2020, at a time when all of our lives has been turned upside down, and we're trying to make sense of all the events that have occurred over the last few weeks. We're all in this together, our patients, our relatives, our communities. And in that change of circumstances, we're not only working differently, but we're also making prudent preparations should things change again. Last autumn, we were fortunate enough to take part in a planning exercise about contingency mental health legislation. At that time, we had no idea that we would actually be looking at activating such legislation for the kind of civil emergency we're currently living through. The college is here to support its members and to promote mental health in Scotland more widely. To do that, we're gathering in all the right guidance and links to the most authoritative, up-to-date websites. If you haven't already, it's worth looking at the COVID Royal College of Psychiatrists in Scotland webpage, where you'll see all of that guidance available. Another part of what the college is doing at this time is to meet with government, and I meet with the mental health minister once a week, as well as other forums. And in that process, it's really important that we have feedback from the membership in Scotland so we can give government up-to-date guidance on the state of play of mental health services. We're going to have a rolling program of surveys of staff. We've already had our first, but I'd like to improve on the response rate to that and use it as a device to track things like availability of PPE and also track emerging themes as they might occur. So, to the topic today, I am delighted that two of my friends and colleagues, Arun Chopra, the Medical Director and Consultant Psychiatrist at Mental Welfare Commission for Scotland, and Roger Smyth, Consultant Liaison Psychiatrist, are able to join us today. They have a wealth of experience and long-standing interest in this topic, and they've done the hard work of going through the detail of the emergency legislation to give us all the headlines. So I'm first of all going to hand over to Roger Smyth.
Thanks very much, John. And if I could have my first slide, please. So over the course of this pandemic so far, we've all, I'm sure, seen sudden, huge changes to our clinical practice and indeed to our daily lives. And in that, I'm also sure we've all been impressed by the resilience and the adaptability and the resourcefulness of our clinical teams. And at the beginning of the pandemic, there were also significant and quite sudden changes made to the law, with several pieces of rapidly introduced legislation, both in Westminster and in Holyrood. There was a national college webinar on the topic last week, but as is the nature of these things, it focused on England and Wales only. So our job today is to present on the legal changes, both current and potential, in Scotland. Could I have the next slide, please? Today I want to cover three pieces of legislation, each of which contains provisions of interest to psychiatrists. There are two specifically Scottish acts and one UK act, which has many provisions affecting Scotland. For each of the two main coronavirus acts, there are powers which are currently active and powers which are now on the statute book but are not yet in force. And these inactive powers will be activated when decided on by Scottish ministers and with advice from the Mental Welfare Commission, the College and the wider profession. they may not need to be enacted at all. However, the three pieces of legislation on your screen now were all passed in late March and early April this year, and they are the Health Protection Coronavirus Restrictions Scotland regulations, and these contain the currently active restrictions on freedom of movement that we're all living under. Then the UK Coronavirus Act 2020, which applies to the whole of the UK, but also has significant provisions for Scotland, and that contains currently active powers relating to potentially infectious persons, but also allows for potential changes to the Mental Health Care and Treatment Scotland Act and the Criminal Procedure Act, although these provisions are not yet in force. And finally, the Coronavirus Scotland Act 2020, which contains currently active changes to the Adults with Incapacity Scotland Act, and also allows for further changes to the working of the Incapacity Act and the Social Work Scotland Act, in particular to the provisions of 13ZA. And again, that is not in force currently. Could I have my next slide, please? So first up, the Health Protection Coronavirus Restrictions Scotland Regulations 2020. And this contains the restrictions that we're all currently living under. And I guess we've all experienced the impact of this law in our daily lives for the last 5 or 6 weeks. There's nothing specific to psychiatrists within this particular piece of legislation, but I mention it because our patients sometimes ask about it, and it's helpful to be as clear as possible to them. Anything we can do to reduce uncertainty at present is, I think, valuable. Could I have my next slide, please? So, Section 5 of this regulation introduces an offence, stating that it is an offence for an individual to leave the place where they are living. However, Section 8 allows for a defence of a reasonable excuse. So you can leave the place you're living if you have a reasonable excuse. And there's quite a wide range of reasonable excuses, and I've picked out the most important ones here. You can leave the place you are living to obtain basic necessities, to take exercise, to seek medical assistance or to access critical public services, to provide care or assistance to a vulnerable person, to travel for the purposes of work when it's not possible to work from home, to maintain child access arrangements, and to avoid injury, illness, or to escape a risk of harm. And we can reassure our patients that if they leave home for these reasonable excuses, they're not at risk of breaking the law. Should note there's nothing in the regulations to suggest that these defences are only available once per day, although I understand that the equivalent regulations in Wales do stipulate this as regards exercise. Could I have the next slide, please? Next then, the UK-wide Coronavirus Act 2020. This is a very wide-ranging act, covering financial, employment and governmental matters, professional regulation and indemnification, legal and judicial changes, and a very wide range of specific schedules containing further powers. I should also notice that it was passed amazingly quickly for such a detailed and all-encompassing piece of legislation, with much, much less parliamentary scrutiny than would normally be the case. First of all, although it doesn't directly affect psychiatrists, I want to point out Schedule 1, Part 3. This contains a wide range of powers for public health officers, and it includes powers of civil detention and quarantine. And these powers are activated in Scotland if the incidence or transmission of coronavirus constitutes a serious and imminent threat to public health in Scotland. Scottish ministers have so ruled this, and therefore these powers are now active. And these are the powers which would be used and should be used by public health officers to detain infectious persons. There are no powers to use mental health detention to detain infected persons, and anyone suggesting such a course should be directed instead towards their public health team and the local public health officers. And in fact, even though the parts of the Coronavirus Act which potentially change Mental Health Act contain significant changes that I'm going to discuss in detail, the criteria for detention under the Mental Health Act are unchanged. The same 5 criteria for civil detention and 4 criteria for forensic detention that we're all familiar with continue unchanged, even if these potential changes come into force. The changes to the Mental Health Act are to do with easing time constraints, potential staffing constraints, and to limiting group meetings. They do not in any way soften the threshold for detention as we've understood it up to now. Changes to the Mental Health Act in Scotland are authorised by Section 10 of the Coronavirus Act and are detailed in Schedule 9. Again, I reiterate, they are not yet active. If they are activated by Scottish ministers, then the changes to the Mental Health Act workings are as I'm going to describe in the next two slides, covering civil detention and forensic detention. So first, civil detention. Next slide, please. So if activated, the changes to civil detention would be as follows. The nurse's holding power would be extended from 3 hours to 6 hours. It could not be renewed as currently. The emergency detention certificate would be extended from 72 hours to 120 hours. Again, that cannot be renewed as currently. A short-term detention order would be able to be granted by an AMP without MHO approval. And unlike now, it would be able to be renewed once, and this would be called the second certificate. And this would come into force lasting 28 days once it was filled out. And so the maximum period of detention under short-term detention, should these powers be enacted, would be 56 days. Going on then to compulsory treatment order, an application can be made with a single AMP recommendation, and it would also set aside conflict of interest regulations except those relating to a familial relationship. So if you were able to get a second AMP, that could be someone who worked in the same hospital or in an independent hospital to which the patient might be sent, or would work in a subordinate position to yourself. But the exemptions related to the conflict of interest regulations relating to familial relationships would remain. For patients on a CTO, medication can be given even after 8 weeks if the AMP has even requested a DMP review, even if the DMP has not issued the certificate. And this would only not apply if the DMP had refused to issue the certificate. Over the time of activation of these powers, mandatory reviews of CTOs would be suspended, and for this period, Mental Health Tribunal for Scotland tribunals can contain 2 rather than 3 members as now. And so next I'll cover the changes to forensic detention. Next slide, please. So on the forensic side, assessment orders would be extended from 14 days to 12 weeks at the discretion of the court. A transfer from treatment direction, or TTD, can be granted on the basis of one AMP report, and the patient can be moved to hospital as soon as practicable, rather than within the 7 days as currently stipulated. And treatment orders, interim compulsion orders, hospital direction, and Section 60C2, acquitted persons detained for medical examination, they again can all be granted on the basis of one AMP report. The patient can be removed as soon as practicable rather than within the 7 days stipulated. And again, mandatory reviews of COs and compulsion order restriction orders are also suspended for the duration. It also allows the tribunal to decide a case without a face-to-face hearing, with relevant parties making written submissions to the tribunal before the decision. Could I have the next slide, please? The Coronavirus Scotland Act 2020 is again a very wide-ranging act covering justice, licensing and children's issues. And Schedule 3 Part 2 contains changes to the Adults with Incapacity Act and the 1968 Social Work Act, some of which are currently active and some of which are yet to be activated. Could I have the next slide, please? So, firstly, the active changes, and these are currently in force. During the period of this current emergency, incapacity certificates, both guardianship orders and incapacity certificates authorising medical treatment under Section 47 will not expire. The clock has stopped on those orders. So if in the normal course of event they would have expired during the current emergency, they do not expire and they continue as is until the end of the emergency period. The Coronavirus Scotland Act also contains potential yet to be activated changes to the workings of the Social Work Scotland Act and Incapacity Act, and in particular the workings of 13ZA, which, as you know, enables social work departments to act to obtain a local authority or community placement for a patient who is incapable but is unresisting, and all agree, including clinical team and relevant others, that this is the correct course. And if activated, this would allow clinicians to move a patient with the help of the social work department into a placement under 13ZA without taking account of the views of the adult and of relevant others, and also potentially would allow the local authority to use 13ZA where a guardianship intervention order or a power of attorney with relevant powers had been granted or applied for. In other words, to place a patient against the wishes of either themselves or the relevant others, even if that person had proxy powers. Now, these final two powers, which, as I say again, have not yet been activated, appear to be directed more towards potentially clearing beds in acute hospitals rather than facilitating correct practice when staffing levels are low or public meetings are not permitted. And unlike the situation in relation to the Mental Health Act powers, they certainly raise significant human rights concerns and would require careful scrutiny if activated. Arun will talk more about how the Mental Welfare Commission plans to monitor the need for these powers and oversee them if enacted. Next slide, please. Arun will also describe the MWC Oversight Committee for these powers. I am the Royal College of Psychiatrists in Scotland rep on the committee, and if you want to contact me in this regard or about any other issue I've discussed, my email is on the screen now. Thank you very much to the College for the invitation to speak and for your attention throughout. I'll hand on here to the next speaker.
Thanks, Roger and John. And as John was saying, these are strange times that we're working in, and as testimony to how different things are, I'm presenting these slides from the shed at the back of the garden. So I hope you can catch some bird song between the slides, but not too much car traffic. Hello to everyone who is listening or watching. Can I have the next slide, please, Aidan? I'm going to talk about three issues. Firstly, I'm going to talk about the use of the existing forms to record any of these emergency powers that people use. And secondly, I'm going to talk about the Commission's role in providing scrutiny and assurance on the use of these powers. And thirdly, I'm going to talk a little bit about how we are currently working within the existing legislation in a socially distant way. I hope that these powers will not need to be used. They are not easements to reduce administrative burden. They are reductions in the safeguards that protect the rights of service users and patients. And whether we use them or not, I hope the next few slides will demonstrate that we are prepared. One of the first things that I'm going to talk to is how we use the current forms that we have to record the use of the powers. I'm going to start with EDCs. So if we could have the next slide, please. So as Roger was saying, EDCs will be extended to up to 120 hours. But of course, at the time when you're detaining someone on an EDC, you won't know whether you'll need longer than the 72 hours. So what we propose to do is ask medical records teams to record in the section of the EDC form that you can see on the screen at the moment, 120 hours in the box. The Commission will be able to pick up the proportion of EDCs that are lasting for longer than 72 hours. Can I have the next slide, please? On short-term detention certificates, as Roger was talking about, it will be possible within the existing laws to have done a short-term detention certificate without consent. But if you've done that, then you will not be able to complete this page of the short-term detention certificate, and you are using new COVID powers to detain. It's really important that you explain why you've used these powers in the box there. And also, if you could write COVID in the top right-hand corner of the first page of the form, that will allow Commission colleagues to know that something isn't quite right. Please tell your patient that you're doing something different. And so the formula will be write COVID, explain why, and inform your patient. I think it's worthwhile pointing out that suppose you do speak to the MHO, who speaks with the patient by the phone and is satisfied that they can discharge their duties this way and consents to the short-term detention certificate, but cannot actually physically sign the form. Remember, you can complete the form on their behalf. You'll still need to explain why, and that's covered in the section at the bottom of that slide. Can I have the next slide, please? As we spoke about just earlier, it will be possible to grant a second short-term detention certificate. The most common scenario might be a back-to-back short-term detention. Simply do not shade the button on this section of the short-term detention form, and that will trigger the Commission to note that this is a possible use of a COVID power. Again, in section 5 of the short-term detention certificate, you'll be able to explain why. Perhaps this could be because you couldn't organise a CTO application because there was no MHO. Writing COVID on the top right-hand corner of the first page of the form will act as a marker too. And of course, remember to inform your patient. Next slide, please. We spoke earlier about CTO applications, which will be possible with a single CTO medical report. This will be relatively straightforward. If you can record this in the other relevant information box in section 8 of the CTO form, which is shown here, you'll be able to explain why. Again, write COVID on the top right-hand corner of the form and inform your patient. Can I have the next slide, please? In this slide, we're talking about how you would record or what would have been a conflict of interest, because the legislation will omit the 2017 regulations that define conflicts of interest that might prevent an AMP from granting a certificate. This is difficult to monitor because you can only sign the forms if you have no conflicts, which with the new legislation you no longer will have. This will hopefully be rare, and so our suggestion here is that you record here on the CTO form, again in section 8, that you would have had a conflict but you now don't. And if you could email us at the email address at the bottom of that slide with the relevant details which are mentioned there, we'll be able to know that this has been a departure from usual practice. Similarly, with short-term detention certificate conflicts, there's a similar process. Please email us with the nature of the conflict that you would have had but you now don't. We will of course be able to pick up AMPs working in private hospitals who are detaining patients there from the address, and we'll be able to track this. Next slide, please. This is the recording of the extended power for nursing colleagues to hold someone for a longer period of time. This is a relatively straightforward one to record. It's a retrospective form, so as you can see at the bottom of the slide, we'd be asking colleagues to record the time here and not shade the 3-hour box if it's between 3 to 6 hours. Next slide, please. With regard to forensic forms that come in to record TTDs and assessment orders, these are dealt with individually anyway, so the extension of powers will be recorded individually and we'll be able to track this. Next slide, please. Coming on to the last couple of slides in this section, suspension of mandatory reviews. Firstly, extending a CTO without completing a mandatory review, simply don't fill in the section where it asks you when you examined your patient, because you wouldn't have done this. You will still need to complete the rest of the form to indicate that you are intending to extend the CTO, and you'd be completing this to the best of your knowledge. Again, if you could write COVID on the top right-hand corner of the first page, explain why in the form and inform your patient, then that will ensure that there is sufficient scrutiny of the suspension of the requirement for mandatory reviews. I've provided the example here from a CTO form, but a similar principle will apply for the suspension of mandatory reviews for compulsion orders. Can I have the next slide, please? I'm going to comment here on the DMP aspect that Roger spoke to. Some of you will have seen that the DMP service is operating in a different way with phone authorizations of RMO treatment plans. I think we would be able to maintain this service thanks to colleagues who are undertaking DMP work and doing this flexibly through the use of phone calls and near me. So even when the powers kick in, we intend to keep the DMP service running in the way that it's currently going. If the workforce does diminish and you still need and you're requesting a DMP authorization, you will still require a DMP authorization, for example, for ECT or for nasogastric feeding. But you can treat with medication so long as you have asked for a DMP visit. The Commission team are currently piloting a new electronic way of requesting a DMP assessment and sending in the Appendix E through this electronic system. We're piloting it in one health board, but if this is successful by the end of this month, we'll be rolling out across Scotland if it's working well. Can I have the next slide, please? I hope that previous section has helped to demonstrate that we are prepared for when these new powers kick in, and we have a sense of how we would be asking you to complete the forms in a way to ensure that, that we're able to provide that scrutiny. I'd like to talk here about some of the data that the Commission is using to help inform whether these powers are switched on or not. John was speaking about a group that meets regularly. We're part of that group that meets with Scottish Government to input into the ministerial advice that helps the Scottish Government to determine whether to switch on these powers or not. Some of the sources that we're using to inform our opinion are the advice line, which is the numbers there, it's still operating, and the email inquiries that are coming in, which are alerting us to difficulties within the system. We're also actively using the data that we collect, for example, any back-to-back short terms, which might indicate a problem in the system, debt falls or rising rates of EDCs. In fact, we just yesterday completed an analysis of a week-by-week breakdown since the end of February to last week of how EDCs are going up or staying the same, and then comparing that to the similar weeks in the past 2 years. We're not finding any difference at the moment, which is an indicator that although there may be pressures in the system, it's not affecting the use of EDCs at the moment. So, and our Commission practitioners are also actively gathering intelligence and data from how services, wards and teams are coping with adapting to socially distant ways of working. So we're using that package of data to help inform a decision about whether we will need to trigger these powers. Next slide, please. If these powers are used, and indeed even now, for trust to be retained in the sector, it is vital that there is proper scrutiny of these powers. I think it was Spider-Man, it was in the Spider-Man movies where there was that sentence that, you know, with power comes responsibility. And in a similar way, with kind of increased power comes increased scrutiny to ensure that there's that balance. So it's vital for checks on this, and the Commission is key in this. We've built on our existing role under the Act about monitoring the Act and promoting best practice, and we will report for post-COVID scrutiny of what powers got used, by whom and where, and we intend to report by health board, by gender, by age, by ethnicity, the presence or absence of learning disability, and other variables. And we hope to consider alongside this the workforce data, which will help to make sense of where the emergency powers were used. Roger talked about the 13ZA system, and we are hoping to, well, we're in the process of setting up a 13ZA notification system to the Commission if emergency 13ZA powers are being used. Can I have the next slide, please, Aidan? We're very grateful. We're not doing this work around scrutiny on our own. There's an advisory group that have been set up to work with the Commission to ensure that we're asking the right questions of our data set to ensure adequate scrutiny of these new powers. And we're really grateful to the members of that scrutiny group who are listed on that list. And Roger is one of the representatives there. Next slide, please. The legislation was designed for a pandemic where the workforce is significantly reduced. But what I think we're all realizing at the moment is that we're dealing with how we cope with social distancing whilst using the existing legislation. And this is requiring, at times, departures from the way that we usually work and the usual advice that's in the Code of Practice. Many practitioners are having difficulties about how we use the current legislation, and you're not alone in this, and we're getting several questions on these sorts of issues. I've mentioned a few questions that we've had recently on the slide. And the Commission is taking a pragmatic view on these kind of questions, whilst at the same time maintaining the protection of human rights of people with mental illness and associated conditions. And each week we're adding to the Commission advice note that contains a Commission view on how to approach these questions and lots of other questions like this. Can I have the next slide, please? I wanted to just highlight how you can access that advice note, and the link is there on the left-hand side of the screen. But if you're using your phone, You can also, if you go onto your phone and track where the coffee signal is for the latest news, you can access the Commission guidance or the latest guidance on COVID advice there. We'll have a new one coming out tomorrow. There is also an advice note for your patients and service users, which can also be linked to from that latest news section. Can I have the next slide, please? Finally, I'd just like to say thank you to John, first of all, for inviting me to take part in this webinar today. And I'd also like to take the opportunity, thanks to our service users, patients, carers and colleagues for getting in touch with the Commission with their experiences, and our Scrutiny Group advisory stakeholders, colleagues at Scottish Government and colleagues at the Commission, who've been working really hard on kind of ensuring that we are ready with a plan on how to deal with these emergency powers if they are triggered. I'm very happy to take any kind of questions by email or by Twitter. The address is there on the screen. And with that, I'll hand over back to John. Thank you.
Thank you very much, Arun, and thank you, Roger. Those were both really excellent presentations where I felt that all the essential information was brought together in a really helpful way. I think one of my take-home messages from this is that the Emergency Mental Health Act measures are permissive but not prescriptive. If we can act in the normal way, even when they are commenced, then we should be acting in that way. And there is nothing in any of these proposals which take away from the principles of the Mental Health Act, that we should be acting in a least restrictive way, in the most protective way for our patients in these extraordinary times. But I've got perhaps just a couple of questions for our speakers today, and I'll ask Arun to go first and then Roger. How likely do you think it is at the current moment that we'll ever have to draw down these powers? And secondly, can you say a little bit more about the way that we're working differently now, and how that impacts on protections for patients?
Thanks, John. On the first question about how likely it is that we're going to draw down on these powers, I mean, as you know, we're reviewing them regularly, and we're having meetings on a weekly, at least, basis to kind of consider whether we need to use them. I think the key to this is partly around workforce data, which Public Health Scotland provide, and that's helpful to know, to get a sense of how much difficulty the system is under, and also the data sets that the college has and that we have about workforce measures and the intelligence that we're gathering. Currently, my view is that I'm not sure that we are at the stage where we require these measures to be triggered. Now, there's a caveat to that, and we are living in these kind of strange lockdown, socially distant times. And at some point, there will be a balance and a judgment call that's going to need to be made about easing lockdown. At that point, we may again have another peak, or we may have an elevated plateau, which might start to impact. And so then there again kind of raises that possibility of needing these measures. And that's the reason why we have to be absolutely ready with kind of how we're going to record and how we're going to use these powers should that happen. On the second point about how we're working with these kind of socially distant measures, I mean, a good example which I've spoken a little bit about is about the DMP system and how the authorizations are being currently done by telephone, and DMPs are phoning up and speaking to named persons, to patients, to RMOs, to other members of staff to get a sense of how things are working. We're also aware of people kind of asking these questions about whether it might be preferable to not go to a GP first for a second report, because of the fact that will mean someone is coming into a hospital or is kind of possibly causing more difficulties, and whether it might be preferable to find an independent colleague within the hospital. So these are the kind of issues that are coming up, and we're having to think through and provide some advice on. What's vitally important is that the college, Scottish Government, the Commission, and other stakeholders in the sector are sharing views and considerations on these powers. We may not always agree, but I think it's really important that we're discussing the positions that we're taking so that rights are protected, and at the same time, we're pragmatic about how we're hoping our colleagues can work?
Thanks for that question, John. I think Arun's answered it very fully, but I'll just give you my thoughts. First of all, I think it's very, very hard to predict anything with any certainty in these circumstances. The person in the world with the most experience of COVID-19 has less than 6-month experience, and we in Scotland have even less. I think the use of these powers is less likely. It seems less likely now than when they were first legislated towards the end of March, when we were at the exponential growth phase and things looked very, very alarming. But the issue about the use of the powers depends mainly on staffing levels, availability of AMPs, and particularly perhaps MHOs. And that availability will be changed very significantly if there is a significant extension of the disease in the community, and particularly if there's a second peak. So quite a lot relies on what happens to the disease in the community after the planned or the mooted relaxation of the lockdown in the coming weeks. And it's also important for those of us sitting here in the central belt to realise that it might be very different in other parts of Scotland, where AMPs and MHOs are much thinner on the ground and are more vulnerable to significant problems if even a small number of staff are lost to ill health. So with that in mind, I think you in the college and Arun in the Commission need feedback from colleagues all over Scotland to guide you in whether these powers need to be enacted and when.
Thank you, Arun Chopra and Roger Smyth, for your presentations this morning. This is the first in a series of Royal College of Psychiatrists in Scotland webinars. We would like your ideas for themes for us to explore and volunteers to contribute. A special thanks to Aidan Reid, our new policy officer in Scotland, for facilitating the webinar this morning. In the meantime, stay safe and see you on the other side. Bye for now.